Hello everyone, and welcome to Taylor Wessing's latest business immigration webinar, Hiring and Retaining Workers in a Brexit World. My name is Charlie Pring, and I'm pleased to be joined today by my colleague Vicky Weiberg. We are both senior counsel in Taylor Wessing's mobility team, and we both specialise in helping UK and international employers with all of their business immigration needs. So over the next 45 minutes or so, we want to share with you some practical guidance on whether, and if so, how European workers in the UK can safeguard their immigration status in light of Brexit, and also in relation to the recent announcements by the UK about proposed settled status. What does it all mean? And then moving away from Brexit, we'll also look at how businesses can make the most of Tier 2 and other visa routes in the UK's immigration rules to help with recruiting the best talent. Despite all of the political uncertainty, we want this webinar to be a practical guide to the proactive steps that UK businesses can try and take to stay ahead of the game. Just a little housekeeping before we get going. If you have any questions, please do type them into the box provided. We will answer some of them as we go along, but we may also catch up with any remaining questions at the end. If you want to go back to the slides or share the webinar later on, it will be available on our website, and our contact details are also at the end of the slides. So, a quick overview again about what we're going to talk about. Net migration figures are actually due out tomorrow, so we'll see whether the trend of the Brexodus, which is EU citizens leaving the UK after Brexit, continues, and then we'll look at what it all means and whether or not UK citizens should do something now to secure their status. And as I said, we'll also look at other ways in which you can use the visa system to get the best talent. So I think you all know about Taylor Wessing. I'm not going to linger on this slide, but just for anyone who hasn't worked with us before, a quick overview about who we are and what we do. International firm. The key thing for this webinar is that we're UK immigration specialists.
Thank you.
I'll just hand you over to Vicky, and she's going to talk to you about the Brexit side.
Thank you, Charlie. I was so keen to get going there that I cut across you. So, good afternoon, everybody. As Charlie said, I'm going to be looking at immigration status after Brexit for EU nationals. I'm sure that everyone on the call is aware of the timeline that we've been working with in the last 18 months or so. Article 50 was triggered in March, but with a build-up before then. And the UK is going to leave the EU in March 2019, unless there's an agreed extension to that 2-year period, which we don't know at the moment whether that will be the case. I think the thing that we get asked most is whether there's a change to European nationals' legal rights before the exit date, and the answer to that is no, there isn't. But there are practical things that you can do if you are a European national, if you have European national staff, things you can do to help them to feel maybe more certain about their futures. So currently citizens of the EEA, which is the wider European Union, Switzerland, and their non-EEA family members can still live and work in the UK. You don't need any particular permission to do so, but attaining a permission can give you some reassurance. There isn't an immigration cut-off date yet in the Prime Minister's letter, which triggered Article 50, but we think it's likely to be March 2019. There's going to be a 2-year transition period during which all EU nationals are going to need to apply for some status to be in the UK, and we'll look at what that means. And the other thing I think to bear in mind is there are a lot of EU nationals in the UK. There are about 3.5 million, with about 1.2 million British citizens across the EU as well. So very much an issue that's going to affect a lot of people. Having said that, and it will be really interesting to see what the statistics say tomorrow that Charlie referred to, the European net migration level is significantly down in the last sort of few months, and it will be interesting to see whether that trend will continue. There's been a lot of headlines, I'm sure you've all read these over the last few months, lots of concern about what Brexit means to European nationals, lots of concern about the ability of companies to recruit European nationals and retain them, And for those of you who work in maybe industries that are reliant on European nationals, such as maybe manufacturing or hotels, for example, you might be already seeing that it's a little bit more difficult to recruit and retain European nationals. So lots of headlines, but not an awful lot of substance maybe until the last couple of weeks. So there were a couple of papers over the summer. One was a leaked paper in The Guardian, and one was a publicly issued paper by the Home Office. The most recent paper that has been issued was a proposal on the 7th of November, which has given us a little bit more clarity about what Brexit will actually mean. And what it has said is just to try to reassure people that anybody in the UK now doesn't have to make an application to preserve their rights. There's actually been encouragement from the Home Office for European nationals not to make applications now, I think partly because the Home Office is being inundated with applications that it hasn't got the time to process, and also because the Home Office is looking to encourage European nationals to make an application for what they're calling settled worker status, which is a status that everybody in the UK from Europe will need to apply for by the end of the transition period. And the government's currently saying that that will be the case for those nationals who also hold permanent residence, and we'll look at what that means a little bit later. The settled worker status will be the new stepping stone for British citizenship, so it's a status that people will have to apply for if they want to become British, and not everybody does. It will be apparently a digital, streamlined and user-friendly process which relies on existing data that the Home Office can access. And that predominantly means we think that the Home Office will be accessing tax records held by HMRC, and that will give them easier access to documentation showing that European nationals have been living and working in the UK. It's going to be an online service for the settled worker status that will be introduced in 2018. We're not too sure when, but the Home Office is looking at having essentially a soft launch in advance of that 2-year transition period to try to encourage people to apply a little bit earlier. And interesting that the Home Office has said that there will be no refusal of application for minor mistakes. We're not really sure what a minor mistake would look like, but maybe not including one document out of the 10 that need to be submitted, for example, or ticking the wrong box on an application that might be considered to be a minor mistake. And those are things that at the moment could be a cause for rejection or could lead to a delay in processing. So that's something interesting to look forward to. The other thing for those of you who've been in the UK maybe as students before transitioning to a working status is that under the new proposals for settled worker status, there'll be no requirement to show that you hold comprehensive sickness insurance as part of your time spent in the UK as a student, or if you've been in the UK as a self-employed person. And that's something that at the moment causes a lot of difficulties because people who've studied here in particular haven't always been aware of the need to hold comprehensive sickness insurance, and so don't retain the paperwork necessary. So that could be a useful thing moving forward. The other thing that's concerning people is the cost, and the government has said that it will cost no more than a passport application, and that's currently £72.50. So the current application cost for permanent residence is £65, so it's looking like it's going to be a similar amount of money. So this all sounds quite positive, doesn't it? There's a new system, a little bit more detail, it's going to be online and streamlined, it's not going to cost too much. What do you do now? So we would say, Charlie and I, that there are still some pros and some reasons to apply for permanent residence now. And permanent residence is a status you can apply for if you have spent at least 5 years in the UK exercising treaty rights, so as a student, a self-employed person, a worker, or a self-sufficient person, someone seeking work, or a mix of those rights. There are a lot of pros about applying for permanent residence now. You will, as a European national, need to have some sort of status in the future. And if you are eligible now, then you could apply, you can give yourself some certainty, and you would only lose that permanent resident status if you leave the UK for 2 years, or if you have to switch to settled worker status. It will be, we understand, much easier to switch from permanent residence to settled worker status, so that can be a good reason to apply now. If you are someone who wishes to become British, and not everybody does, then holding permanent residence or settled worker status means that you are a step closer to becoming British. So if you do wish to apply for citizenship here, you've lived here a long time, you'd like to be British and you could be dual citizen, then you could think about applying now so that you apply for permanent residence and then citizenship before the rush that we believe will come. Arguably, it's better the devil you know. We know at the moment that applications are relatively straightforward. There's an online process. The applications we're seeing are generally being turned around in 2 to 3 months, so it doesn't take too long. And we're not sure how the new system, for example, will cope with complicated applications. So it's maybe one thing if you've been in the UK as a worker and you have tax records that are easy to check, but what if you've studied for a bit, you've been self-employed, you've maybe not had a job for a few months, and then you've worked? How is the new system going to cope with that? We know what the system looks like now, and we know how to make those applications. Interestingly, actually, another reason to apply now is the Home Office is stating the new system will be very streamlined and digital and simple. But with the sheer number of European nationals in the UK who need to apply for a new status, there's going to be a lot of applications that need to be processed. And it looks like something like about 15 applications every minute of working time at the Home Office are going to need to be processed. And we're not sure how the Home Office will cope with that. The IT systems generally are slow. They don't tend to cope very well with high volume applications. So applying now with a system we know works most of the time could be worth considering. Also, another thing to think about is we're not clear on how family members will be dealt with after Brexit. So if you're somebody in the UK and you have extended family members you want to bring in, so non-EU national family members that you want to bring to the UK, you can do that under European rules. The rules, the British rules, are much more restricted to your spouse, your partner, your children. You can't bring family members such as parents into the UK under British immigration rules. So if you have a wider family that you're interested in bringing to the UK, applying for permanent residence now could actually be beneficial for you.
And Vicky, we've just had our first question in from Philippe, and he says that his friend has told him that the permanent residence application form is 80 pages long. Is that true?
No, thanks, Philippe. It's a good question. The Home Office has been working really hard in the last few months to try to make the permanent residence application process simpler. And it's right that historically the application form was very, very long. It's 80 or so pages long. For most people now, they can actually make an online application, and the form is more like 6 to 8 pages long, depending on whether any dependent family members are part of that. So it's a much simpler form. Applying online also gives you access to something called the EPRS, which is a checking service, which means that you don't need to send your passport to the Home Office. So the form is much simpler now, and I think it's something that most people would be able to fill in somewhere between 20 to 30 minutes.
And unlike the 80-page form that we used to have, an applicant for permanent residence don't have to list every individual absence from the UK. You just need to tick a box to say you haven't been absent more than 6 months a year.
Absolutely, and that's something that I know has been causing people real issues, particularly for those of you who travel a lot with work. Listing your absence can be very difficult. So there's been a lot of Home Office changes to the forms which have actually made it a lot simpler to make an application now. And I think most people, particularly those of you who've been in the UK just as a worker, will find it's a very simple process now. On online form, your P60s, and that's more or less it. So really good reason to make an application now. Having said that, there might be reasons to wait, and those are the ones that we've listed on the slide here. If the new system does rely on HMRC data, then arguably it's going to be much simpler going forward. Maybe you don't have to submit any supporting documents at all. You have to give your national insurance number, for example, and the Home Office will be able to check with HMRC that you have been working in the UK for the 5 years. So that could be very simple, maybe less burdensome than if you're in a situation where you just haven't retained your documentation. As I mentioned a couple of slides ago, the Home Office is saying that they are removing the requirement to evidence comprehensive sickness insurance if you've been studying or you've been self-employed, and that can be really, really helpful. And apologies, Charlie has just pointed out to me it's not for self-employed, it's for those who've been self-sufficient. So apologies to confuse. So if you have been in the UK as a self-sufficient person, or if you've been studying, there won't be the need to show that you've got comprehensive sickness insurance moving forward, and that could be very, very helpful, as that can be a real difficult documentation to evidence. If you apply for permanent residence now, you are still going to have to switch to the settled worker status unless you've applied for citizenship before the end of that 2-year transition period, so before March 2021. So you might say, why would I want to make 2 applications when I could wait and just make 1? And lastly, and I'm not sure how much, to be honest, I believe this, but it's a point worth making, is the 7th of November paper was just a proposal. It hasn't been set in stone. It may be that nothing is needed in the future, particularly if you hold permanent residence, you may need nothing, or it may be that the government pushes back the need to make an application altogether. It's a really big challenge that they have, and it may be that going forward you don't need to make an application. So again, why make an application now if you don't need to?
And Vicky, we just had our second question in from Anna, who's asked a question that we've heard many, many times. She says that she's lived in the UK for 30 years and paid tax for all of that period. Surely she doesn't have to do anything at all.
And I think, yeah, Charlie, that's a question, as you said, we get asked a lot. Anna, thank you for that. I think it's important to understand that the government's position at the moment is, regardless of how long you've been in the UK, you are going to need a piece of paper to evidence that you are here as somebody who has exercised their treaty rights and has settled worker, and that's the case whether you've been here for 5 years, 10 years, 20 or 30 years. So Anna, I'm afraid you will need to make an application. If you've been here for that period of time, one thing you'll need to think about is what 5-year period you want to rely on, and we'll have a look at that a little bit later. And you might decide that you do want to be British. You've been here a long time. It might feel like something that you want to do. So we would recommend that you look at your options now. Applying for permanent residence won't impact on your tax status. So we would say make an application now, but going forward, even if you've been here a long period of time, unfortunately the government is going to ask you to make an application. So if you do want to make a permanent residence application, as we've said, you have to have spent 5 years continuously in the UK. It doesn't have to be the last 5 years, and often the simplest applications to make are ones which tie into tax years, for example. So you might want to apply for the tax year period from 5th of April 2011 to 5th of April 2016, for example. That can be quite an easy period to rely on. If you've been working, you'll have P60s for that period, and that's all of the evidence you'll need of residence and exercising treaty rights. So nice and simple, your HR team should be able to help you with that, and if you are dialing in as an HR professional, that should be something hopefully you can find on your systems relatively easily. You have to be a qualified person, so you have to be exercising treaty rights. You can't just be in the UK without doing something, so you have to show that you've been working or studying, or if you haven't got a job, that you've been looking for a job. You have to be a person of good character, which just means that you essentially don't have a criminal record, for example. You do have to disclose things like driving offences, but offences like speeding or tickets should be overlooked, but you do need to tell the Home Office because they will be checking on your good character. As Charlie said, you don't have to list your absences anymore on the online form, but you can't have been absent from the UK for more than 6 months in each of those 12-month periods for your 5 years residence. So it may be that if you've been in the UK a long time, you've already acquired permanent residence before you have a big period of absence, and that would be something to discuss with us, looking at the best period to apply on. And you have to provide some documentary evidence of your exercise of treaty rights. So as I say, as a worker, that will be your P60s. As a student, you would need to provide evidence of studying. At the moment, your comprehensive sickness insurance. And if you've been financially supported by your parents, for example, you would need to provide evidence of that as well. I think it's just worth flagging that if you're an Irish citizen in the UK or you have Irish citizens in your workforce, they are already considered settled without permanent residence, so they don't need to do anything. Having said that, I have a lot of Irish friends and we have Irish colleagues, and they can make an application and they may wish to do so, but there is no need at present. So just looking quickly, there are a couple of different submission routes for the application currently. You can submit by post, and you can submit on this EPRS route, which is the checking route. The benefits of the EPRS is that it's a much shorter form, about, as I say, 6 or 7 pages. You have to use your passport, so if you're a European national in the UK with just an identity card, you can't use that on the EPRS. By that, if you just have an ID card, you have to submit by post. And with the EPRS, you submit your online form, you attend a registry office. There are 8 sites in London, for example. They would take a copy of your passport and they would submit your application for you. It's quite simple. You pay somewhere between £15 and £25, £10 to £25 for that service. And the real benefit is that you get to keep your passport, and I think that's something that really appeals to most people. You will find that if you're a certain type of application, you do have to submit by post, and that's generally if you've received financial support during your time in the UK, or you've been financially supporting someone else. So often for students, they're going to be needing to submit by post. So one of the questions we're really being asked a lot at the moment is, you've applied for permanent residence, you're happy holding permanent residence, should you apply for British citizenship? And it's a really interesting, I think, quite an emotive question. If you want to apply for British citizenship, you have to have held your permanent residence for 12 months. If you rely on a historic period to apply for permanent residence, you might well already be granted permanent residence that's deemed to have been held for at least 12 months. So using the example earlier of applying for the period between April 2011 and April 2016, if you make that application now, you'll already be deemed to have held your permanent residence document for that 12-month period and can apply for citizenship straight away. So that's something to bear in mind. I think whether or not you want to become British is really a question of identity, because you might have no interest in being British. It might be something that you are interested in. You might, for example, want to vote in the UK, particularly at the moment, and being British would allow you to do that. It would also preserve your status if you plan to relocate from the UK. So a lot of our clients have been here a long time. They are thinking about maybe moving back overseas for a period of time. And you can lose permanent residence if you spend more than 2 years outside the UK. You're not going to lose your British citizenship. So that could be something worth thinking about. And particularly important, for example, if you want to have children, maybe that will impact on their future as well. I think there are a few things you would need to think about, though. You need to think about your non-European family members. Until fairly recently, under UK law, you're not permitted to bring wider family members to the UK as a British national, so that would be parents, for example. There was a recent case called Loons, which challenged that, and we're waiting for the government to change their position. But I think moving forward, post-Brexit, that more restrictive position is probably going to apply again. You need to check the impact on your existing citizenship. It may be that you're from a country which doesn't permit you to hold dual citizenship. For example, up until recently, as a Dutch national, you couldn't be dual British and Dutch citizen. The government in Holland has issued a press release saying that they are going to change that position for those people who are Dutch nationals living in the UK. So there's a little bit of movement probably we can see in the future. You might want to consider things like your tax status. If you're somebody who is not domiciled in the UK for tax purposes, then applying to become British may impact on your tax status, and that's something that you need to take advice on, and we can obviously facilitate that for you. And also just consider things like your legal commitments. If you're somebody who comes from a country that has mandatory national service, then applying to become British might impact on that. And again, you should think about that before making your application. So just to finish off with my section, if you're somebody who works in your company's HR team, you might want to be thinking about over the next year, 18 months, and actually in the transition period as well, how can you support your workers in the EU? What we're seeing is a real shift in approach, and most companies that we talk to do want to actively support their staff or give them some support, but they are very mindful of costs as well. So I think if you are wanting to support your staff, that's great. You might want to think about how you're supporting your non-EU staff, and you might want to think about how you're supporting your British staff. You might have EU dependents, for example. So if your British staff have EU spouses, that might be something that you want to think about.
And Vicky, this ties in really well with a question we've just received from Lars, who's an HR director. He says that their company has a UK workforce with 50% EU citizens. What do you recommend that they do to help them and support them?
Yeah, great. Thank you for that question. This is not uncommon at all, and we're finding with a lot of our clients that they have a large number of EU nationals working in their UK offices. Things that we're doing, which I think can be quite helpful, are providing sort of information through presentations. So Charlie and I have been in some of our clients, and we've run seminars for their EU national workforce to give support and advice on applications. That can be really helpful because it means that you're hopefully answering the questions people tend to be very similar, and you're actually answering all of those in one go, and that can be really helpful. It also maybe keeps the cost down because that's more cost effective than providing individual support. But you might want to do that. You might want to also provide the sort of support that looks at people's applications before they're submitted, or answers questions. We have lots of resources, FAQs, template information we can give you which would help support your staff without necessarily spending time looking at individual applications. So I think those are things that you might want to do, that in reality you are going to need to make an application as an EU national moving forward. So helping support your staff now means that you're going to be maybe ahead of the curve in doing so. You might also, as a company, want to consider things like, if you're recruiting high-level European nationals into the business at the moment, those staff might want to have protection against future changes or relocation costs to the extent they can't stay in the UK after Brexit. And realistically, anyone moving here now will be protected. But you might find that when you're recruiting now, you have staff who are actually seeking that additional reassurance or maybe clauses in their contract to show that you will support them. And that's something, again, that we can support you with. So looking into a crystal ball and to the best that we can do so, and it's difficult at the moment to know in all certainty what the government's planning to do. But what's interesting is we're already seeing that companies are having difficulties to recruit people into certain roles. Interestingly, we hear on the grapevine that the Home Office itself is struggling to recruit people to work in its European team to process applications for permanent residence documentation, which doesn't bode well for the rest of us, really, does it? We understand that there are going to be restrictions on low-skilled workers, and that visas for low-skilled workers probably will be limited to 2 years, and that was something in a leaked paper that The Guardian picked up over the summer. There may well be restrictions, we think there are likely to be, on high-skilled workers, so bringing high-skilled European workers in line with the Tier 2 system that Charlie will talk about next, where those visas are going to be limited to 5 years with no possibility of settlement. That would be much like our intra-company transfer route for non-EU nationals. Not ideal if you have staff members who are looking to sort of settle in the UK on a permanent basis. So we think those are likely to be issues moving forward. And we've talked a little bit already about the impact on extended family members and the Loon's case. I think if you have staff who are concerned about being able to bring non-EU extended family members in now, it would be better to do it under the European rules, which are much more flexible, than wait and see what the future holds. So there's a lot that's going to be happening. There's not a lot of guidance at the moment, but one area that we do have more certainty on is the existing non-EU national systems. And I'll pass on to Charlie to talk about that now.
Yeah, thanks, Vicky. So what I wanted to cover is the existing visa system for non-Europeans, what visa routes are available, what options do you have, either to use Tier 2 for work permits or other alternative systems. It'll also give you an eye towards what the system might be for European citizens after Brexit, because the same sort of rules may start to filter in for European citizens too. So what are we seeing as migration trends? What do we think is happening? Well, we expect non-European migration to the UK to remain high. We anticipate tomorrow that the latest figures will show EU net migration to have reduced post-Brexit, but non-EU migration has stayed fairly high. There are protectionist immigration policies in other countries which force people to move around the globe. The US, for example, we help clients to get visas for a number of US workers who've been denied visas in the US, particularly in the H-1B visa category, where there's a lottery and a lot of very talented people are unsuccessful just purely because there's a quota system. There's going to be a shrinking EU talent pool in the UK because of Brexit and those lower numbers of EU citizens in the UK. The UK has had a long-term problem with skills shortage, and with the technology innovation which is coming through rapidly, access to talent is going to be crucial going forwards. And we're also seeing, on the back of Brexit, other non-European countries that the UK wants to trade with once we've left the EU. They want to have a more relaxed immigration system in the UK in exchange for doing a free trade deal. So India is one example where they're saying, well, the UK should let us have more visas in exchange for doing a good trade deal. So what does that mean for companies and HR teams? Well, it just needs more thought, I think, around workforce planning, having a coordinated approach around the visa arrangement process, relocation packages, onboarding, right to work checks is now a really, really important part of any business, whether or not they sponsor work permits or not. It's a crucial part of their recruitment process. Tax issues for those mobile employees that are spending time in more than one country and often multiple countries, and whether or not the local tax regime is triggered by length of stay. Personal security issues for those employees that are going to higher risk jurisdictions, and for those mobile employees, how do you maintain the development, the training, the management of those staff that are working remotely, perhaps on a client site in another country? So one of the things we always speak to our clients about is, often the assumption is in a work visa situation that we go straight to Tier 2. That's our sponsored work permit system in the UK. But before you sponsor a visa as a business, it's always worth thinking about whether or not there is an alternative route that might be cheaper, faster, and avoiding the compliance that goes with a Tier 2 visa. So starting from the top and going clockwise around the clock here, there's a sole representative visa, and that's only available for companies that are launching in the UK, so overseas businesses that are starting up for the first time, not for those companies that already have a presence. There's a Tier 1 exceptional talent visa, which is, as the name suggests, designed for recognised leaders in their field, which includes the arts, technology, science, and for those workers that have exceptional promise as well. At the moment, there's a 1,000 allocation per year, and that's across all the sectors. So, for example, in technology, it's 200 visas per year. The government has just announced in the last week or so that quota will be increased to 2,000 per year, so 400 across each of the five sectors. And traditionally, because of the high bar on qualification, there's been relatively low numbers of those visas granted. But we hope that there's going to be a more streamlined process and perhaps some relaxed guidance on who might qualify for that going forwards. Tier 1 entrepreneurs and graduate entrepreneurs are for business owners and founders. And in most cases, with the entrepreneur visa, you need as an individual to have at least £200,000 to invest in the UK. And with the graduate entrepreneur, you need to be endorsed by a university as having a strong business plan. One area where many of our clients are hiring workers on visas is the Tier 4 student route. So that's for non-European students who are at a UK university. And there are some extra things to think about as an employer when you recruit somebody on a Tier 4 visa. The first thing to remember is that their visa is primarily for study. And so in most cases, there is a 20-hour per week restriction on work during term time. And to address that and to make sure that the worker is not going beyond that limit, as an employer, you must get, as well as the normal right to work check, extra evidence from the student about their term time. So that might be a letter from the university or a printout of their timetable, so that you can be sure as an employer that you're not going beyond that 20-hour limit. They're also not allowed to do a permanent vacancy, so they should be in a sort of temporary, maybe project-based role.
And Charlie, actually, this is maybe a good time to raise a question we've had from Adriana. Thank you for your question. Adriana says, we have a temporary employee on a Tier 4 visa which ends in February 2018. How can their company make that Tier 4 visa holder a full-time employee?
Well, outside any other personal circumstances that might give a visa route, so something like a family member, for example, who's British, spouse or partner, the normal route to convert that into full-time employment is through Tier 2 General, which requires the business to have a Tier 2 sponsor license and to sponsor the employee in a full-time job, which has a minimum salary, a minimum graduate level skill level. And the good news for Tier 4 students and the employer as well is that there is an exemption from the normal rule that says that the employer must advertise the job locally and give priority to settled applicants as an exemption for graduates, as long as the application is made before the Tier 4 visa expires in February, and as long as the graduate has successfully completed their course from a recognised institution. So that would then enable a permanent sponsorship, potentially of up to 5 years, depending on the salary level and the circumstances. Going back to our alternatives, a partner visa is one which is often a great solution for some people who happen to have a partner or spouse who's British or European, certainly until Brexit, where that would entitle the employee to gain a full work visa without any restrictions, or barely any restrictions, while they're in the UK. I guess unless she gets exempted by the government, this is what Meghan Markle would be thinking about doing for you royal family fans, in giving her a right to come to the UK. The Tier 5 youth mobility and the Tier 5 intern visa is a great temporary visa route. The youth mobility is only available to 6 or 7 different countries, the main ones being Canada, Australia and New Zealand, but it gives a 2-year visa route to those citizens of those countries who are 30 or under, and they're allowed to do any job at any pay, but again, to stay beyond 2 years would need to be sponsored in Tier 2. Tier 5 interns is for undergraduates and recent graduates of any nationality, but it requires a commercial sponsor that you'd need to sign up with as an organisation. And then finally, UK ancestry is another really good route available for citizens of Commonwealth countries who have a grandparent that was born in the UK, and that entitles the employee, as long as they're planning to work or seek work while they're in the UK, to get a 5-year visa leading to permanent residency. So these sorts of routes, you don't want to miss them if they're available, so it's always worth investigating before arranging a Tier 2 visa, just to check whether or not they might be an option. So going on to Tier 2, it's because of the restrictions the UK has brought in over the last few years, it's a crucial recruitment tool for UK businesses to be able to sponsor work permits for skilled non-European workers. And a couple of practical points for those of you that have got sponsor licenses already. It's worth checking how your sponsor is designated in the sponsor management system, whether it's large or small. And that's important because the immigration skills charge, which came in last April, which sets a tax on you as a sponsor depending on your size of organisation, and you don't want to be either overpaying or underpaying when you're assigning certificates of sponsorship. So it's really important that that's right. And if it's currently wrong, so for example, if your business has grown or perhaps you've been acquired by a listed company overseas, which makes you large rather than small, that you need to make an application to update that so that you're paying the right fee in the future as a really important compliance point. On staying with the immigration skills charge, the Conservative manifesto from the general election this year talked about the intention of the Conservative Party to double the immigration skills tax. So that would be £2,000 for medium and large sponsors, and about £750 a year for small sponsors and charities by 2022. At the moment, there's no exact timing on that, but it's worth keeping in the back of your mind for future budgeting. Something that all sponsors need to be thinking about coming up in the next 2 or 3 months is that we're approaching in January the start of the period in which you can request your certificate of sponsorship allocation for the year April 18 to April 19. That's so if you need any visa needs, whether that's extension or new hires, you need to put through the request to let the government know how many you want. We can help you with that. And it's important, we think, because of restrictions on personnel, resourcing and Brexit-related delays, to get a certificate request of maybe 1 or 2, even if you don't think you've got an anticipated need, because things do change and it's always easier to get one now rather than later on and avoid having to pay extra government fees to expedite a request that you could have in the system ready to go. Some good news from an immigration side, which we don't always have, which is that we have seen some practical changes to the system to try and make it a bit more user-friendly. Generally around the world, there are more premium processing options. In a number of countries, including the US, you can get sort of 24, 48-hour processing time if you're willing to pay a very high government fee. And for those of you that have a Tier 2 license and you're requesting extra certificates of sponsorship, or if you're changing personnel on the license, it is possible now to expedite those requests. They can sometimes take, or used to take, 2 to 3 months. You can pay £200 per request to get those done within a few days, where you've got an urgent need, so for example, an urgent hire or key personnel has just left, they can be a really valuable way of getting through a quick decision.
And Charlie, before we move on to look at Tier 2 General and Tier 2 ICT, we've had a question from Sarah. Sarah's company has a very small office in the UK. They've only got 5 people. They want to recruit someone. They don't have a sponsorship licence. She's asking how difficult is it to get one. She understands it can be quite tricky.
Yeah, it can be. So thanks, Sarah. So we help lots of clients of all sizes, including startups, to get a sponsor licence. The key thing is that there is at least 1 employee on the ground in the UK, and that should be somebody who's sufficiently senior to take responsibility for the various duties that go with holding a licence. So that's some compliance duties that we'll come on to talk about, and responsibility around things like record keeping and reporting duties to the government. But there's no rule that says you have to be a certain size to be able to get a sponsor license. It's possible to get one just with 1 employee. You need to be able to show you're a reputable business and that you'll be able to support workers. But there is no extra hurdles for small companies. It's just that the same rules apply to them as apply to large companies, and so therefore they still need to be on top of the compliance. Okay, so moving on. Tier 2 General For those of you that know the system, this is the visa route that allows you to recruit mainly external hires, so that they might be outside the UK or they might be inside the UK at another company. They might be a Tier 4 graduate like we were speaking about before. Couple of practical points. Remember that the government expects there to be salary progression for workers. So if you are taking on either as somebody who's 26 or under or a recent graduate on the new entrant rate where there's a lower minimum salary, to be able to extend that beyond 3 years, you must reach the experienced rate, and there's a different rate for each job. It's very job specific, and they do get refreshed from time to time. And then to get permanent residency after a minimum of 5 years in Tier 2 General, there is a flat rate minimum salary, regardless of the job. So, for example, from April 2020, that will be £36,200. Whatever the employee is on during the 5 years, they're going to have to have reached that level to be able to get indefinite leave to remain. With the resident labour market test, that's the advertising to make sure there are no suitably qualified local employees. It's really, really important to keep a comprehensive paper trail, including copies of the adverts, copies of interview notes, copies of or details of why you rejected applicants who were settled workers. Keeping those on the personnel file is crucial. For those businesses that are in the technology sector, one point that sometimes gets missed is that there are now 4 different types of job category in the shortage occupation list, which is in Appendix K, that are technology-related roles, so senior developer roles, for example. They can qualify in some circumstances, depending on experience required, for shortage occupation, which means you get exemption from advertising. But to be able to use that, the Tier 2 sponsor license must be registered as a sort of Digitech. It needs an extra registration, which requires the sponsor to have either between 20 and 250 employees, or have less than 20 employees but have Department of International Trade endorsement. Now, if you're taking on, and this is quite common, if you're taking on an employee who currently has a Tier 2 General visa with another UK employer, there are a few things just to think about when you're doing that. The first is that you'll be in conversations with the candidate, and often you might be ready to make an offer before you have advertised. If you haven't done an immigration compliant resident labour market test, you will need to do that before you can make a job offer, because you don't want anything to create the impression that you've gone into that advertising process with your mind made up. You need to think about the timing of the employee's resignation. They will be at risk if they resign from their current employment before they have gained the visa with your organisation, because if they resign but fail to get the visa with you, they'll be left exposed. They'll have to find another sponsor, or possibly even have to leave the UK, in which case a cooling off period would apply. And then finally, when you're thinking with the business about the hiring timeline of taking on somebody who's currently at another business with a Tier 2, you need to factor in what their notice period is. So you can go ahead, you have to do your advertising, then you have to get them the visa with you, and only then if they give notice. If they've got, for example, a 3-month notice period, you need to factor that in, and it may then be that the start date could be 4 to 6 months away from when you're having those conversations. So for those of you that are operating Tier 2 intra-company transfers, if you've got overseas entities and your license is covering ICTs as well, a couple of practical points. Multinationals are often changing the identity of some of their international offices. You might be acquiring businesses, you might be disposing of companies overseas. It's always worth checking that your ICT list, which you probably would have submitted at the time of the first application, is still up to date, to make sure you can still operate ICT, because you can only get an ICT visa for an employee of a company that's been approved on the license. One thing that came in earlier this year is a new flat rate £41,500 salary for all ICT assignments. So there used to be a lower rate for short-term assignments of up to 12 months, I should say. That has now been replaced. So regardless of the length of the assignment, the absolute minimum salary for an ICT is 41,500 sterling. And in some cases, if the minimum for the job as set by the government is higher than that, then you have to pay the higher amount. If you're paying, and this is quite common with international assignments, if you're paying in an overseas currency, you must ensure that the converted sterling amount is above 41,500 or the minimum for the role if that's higher at all times. So in other words, the risk of currency fluctuation is on you as the employer if you choose to pay in an overseas currency. And then there might be a couple of beneficial changes that came through within the last 6-12 months that you can take advantage of. The first is that there's no longer a need for 12 months service overseas if the proposed UK salary on the COS, the certificate of sponsorship, will be over 73,900 per year. So for those high earners, they could be with the international office a matter of weeks or months. A high earning ICT holder can stay 9 years rather than the usual capped 5 years if salary will be at least, UK salary will be at least £120,000. So that's a great way for people to stay longer, but the visa still won't be eligible for permanent residency. And then finally, there's been a change within the last 12 months or so that if the candidate, if the employee is currently in the UK, so for example, they might have got a Tier 5 youth mobility visa, but they had 12 months overseas service with the same group before coming to the UK on that other status, they can still qualify for ICT. In other words, it doesn't have to be the last 12 months in order to be able to get an ICT. You can look backwards and see whether there's 12 months continuous service at some point in the past.
Charlie, I've had an interesting question in from James. His company is looking to transfer somebody to the UK from America, and they're just wondering what the main differences are between using the Tier 2 General and the Tier 2 ICT route, and if you would recommend a particular option for them with someone who's already been employed by them for a few years.
So the main difference between the two routes is that Tier 2 General does lead to permanent residency or indefinite leave to remain after 5 years, continuous stay, whereas intra-company transfers do not. The ICT is designed as a temporary route for either 5 or 9 years stay, and it will never be eligible for that permanent stay. So for example, sometimes employees that have families that want to settle into schools, they may prefer to look at Tier 2 General rather than ICT so that they've got that option of long-term stay. And it's really important to make that decision before the first visa is issued, because once you get onto an ICT, you can't change track onto General unless you're a very high earner. Now, for those executives and high earners who've got a UK salary of above £160,000 a year, or actually 159,600, but that sort of level of pay as a guaranteed salary, so excluding any variable pay, they may as well get General because they'll get eligibility for permanent stay, but crucially the business will get an exemption from having to advertise the role which would normally have to do for General. So I would say in most cases for international assignments, if the salary is below that sort of level, the company will look at an ICT because that's the quickest way to achieve the visa, but crucially they also get a pass on having to advertise the role. They can bring someone in straight away based on them needing their company experience. So finally, just to wrap up about sponsor licenses, what we found is that it's equally as important to keep an eye on compliance as it is to get the visa in the first place, because if the compliance is not maintained, you'll end up losing the license and therefore losing all of your visas and the key personnel that you're sponsoring. So the key question we're always asking our sponsors is, are they ready for an audit? Because those audits are happening regularly, and they're typically unannounced, so they're given without any warning at all. So the sorts of things you need to think about as a sponsor are your HR processes, your personnel files, are they up to date with Appendix D records that you're required to keep for all Tier 2 employees. An audit will involve an interview with the authorising officer, perhaps some other personnel as well, but also one-on-one with several Tier 2 employees. And they'll want to ask questions to the employee to make sure that the role that they perform in practice is consistent with what you've put on the job description, to make sure that they're getting paid at the rate that you've said they are, and to make sure that everything seems to be above board. There's a particular compliance issue with third-party client sites following a review of the guidance in the last year or two. So where you've got a Tier 2 employee working at a client side, it's really important that that working arrangement is made under a client contract with the client, which is time limited for services, and crucially that you've told the third party client that they can be audited as well by the government. And indeed, we've heard anecdotal stories of UKVI turning up simultaneously at both the sponsor and the client to do audits. And the reason it's so important is that if there are compliance breaches, UKVI can downgrade or in the worst cases revoke the license, and revocation would automatically cancel any Tier 2 visas you have at that time, crucially with no right of appeal and with a cooling off period for both the business from getting another license and potentially for employees as well if they've had to leave the UK. So the key things you want to look at are Appendix D, which is on the government website, and also the Tier 2 sponsor guidance, which is the comprehensive overview of everything you need to do as a sponsor. So finally, looking at the future, right to work checks. There's been a lot of employment-related litigation about the gig economy involving Uber and Deliveroo and other online platforms as to those worker status, whether or not they're self-employed or whether they should have some form of employment rights. At the moment, when you're doing right to work checks, legally you're only required to do them on, quote, employees, although the best practice in the guidance is to extend that to contractors as well. We can see a trend of right to work checks extending towards contractors, perhaps to those people from third-party agencies that you have on your site, and making sure that you as an organisation are ensuring that those checks have been done once they're on your premises. So I think there's going to be an expansion of that over time. We talked about the Tier 1 exceptional talent, the increased quota. There's also talk about, for researchers and academics, there's talk about reducing the period of settlement for those categories of exceptional talent visas from 5 years to 3 years, and perhaps an improved, more streamlined process. Vicky's talked about the sort of Brexit system. And then finally, there was a hidden away in the budget documents recently, earlier this month, there was reference to the government making it quicker for highly skilled students to apply for work after completing their degrees, which may, we're thinking, may well be a rollout of a pilot from earlier in the year, which says that as long as the course has been completed and the student is at a recognised university, which has been approved by the Home Office, they may be able to switch into Tier 2 immediately after completion, rather than having to wait 2 or 3 months when they actually graduate. But we'll have to wait and see. But there's something coming down the track at some point.
Thank you, Charlie. I think that brings us to the end of the hour. We can't see that we have any further questions, so it just remains for me to say thank you for joining us this afternoon. We hope you found the session really interesting and helpful, and if you have any specific questions that you would like to raise with us, our contact details are on the slide, and we would be delighted to hear from you. Thank you very much, and goodbye.
Thank you.